All right. Well, thanks everybody. Thanks for joining our webinar today. My name is Ellen Berge. I'm here with several friends and a colleague from across the globe to give you an overview of laws in various jurisdictions that apply to automatic renewal offers and subscriptions. So that is me, Ellen Berge, on the screen. I'm a partner here in the Washington, D.C. office of Venable, and I have my colleague, Shahin Rothermel, also with me here, a partner at Venable in D.C. What we're going to do today is give you an overview of laws in the United States first. It's an area where we think, having talked with our panelists today, that there's a lot of things happening. We've got new federal laws and state laws constantly changing and evolving here that are really impacting companies selling to consumers in the U.S., no matter where the companies are located, that really relate to subscription sales, automatic renewal offers, membership clubs, those types of things. And then after we cover the U.S. portion, we will turn it over to some of our other colleagues and friends here. Maybe the next slide, our other speakers here. So we have Jacqueline Reeve from Miller Thompson, who will talk about things going on in Canada. We have Brinsley Dresden, who's going to talk about what's going on in the UK. Virginie Liebermann is going to cover Luxembourg, and Kanu Priya is going to cover India. So we're really excited. Shahin and I know the US portion of this quite well, obviously, but we're looking forward to learning from our colleagues here and hope that you all will learn a lot too. So without further ado, let's get into the content, and I'll turn it over to Shahin.
Thanks, Ellen. As Ellen mentioned, there's a lot of moving parts here in the US in terms of automatic renewal laws, both on the federal level and the state level. On the federal level, the Restore Online Shoppers Confidence Act applies to online merchants that sell a product or service on a negative option basis to comply with certain requirements. The law defines negative options as any type of program whereby a consumer will continue to be billed unless they take an affirmative act to stop the charges. The three main requirements under ROSCA are that you clearly and conspicuously disclose the material terms of the transaction before obtaining billing information, obtaining the consumer's express informed consent before charging them, and providing a simple mechanism for people to stop the recurring charges to cancel. The Restore Online Shoppers Confidence Act, or ROSCA, applies to online sales. There's also a telemarketing sales rule that the Federal Trade Commission, the government agency that enforces consumer protection laws on the federal level, it administers a TSR, and that applies to telephone sales, whether those are inbound or outbound, where you have sales of negative option or automatic renewals. And the general catch-all law is the Section 5 of the FTC Act that generally prohibits unfair or deceptive sales practices. There have been a number of state laws. I think over half the states in the United States now have laws that apply to automatic renewal programs, some being more onerous than others. There are significant laws right now in California, New York, Virginia, Vermont, District of Columbia that have very technical requirements. There's new laws that are effective this year in Colorado, Delaware, and Illinois. And California also has new amendments to its laws. And these laws apply not only to online, not only to telephone, but also to things like in-person sales and magazine or catalog sales, which we still see direct mail. The state laws typically address both the general prohibition on being deceptive, misleading, or unfair to consumers when you're selling something on an automatic renewal basis, but also very particular elements that have to be met, including very specific disclosures. They set a standard for what it means for those disclosures to be sufficiently conspicuously conveyed to consumers, order confirmations that have to meet certain requirements and provide specific disclosures, cancellation policies and mechanisms. California is a big one that has very specific requirements of what you have to let people do to cancel, renewal notices, and notices of any material changes to the automatic renewal offer. So we'll go through a couple of the key requirements of the U.S., the first being the disclosures. The general rule of the road is that you need to disclose the fact that that consumers will continue to be charged till they cancel, a description of the cancellation policy, the amount of the recurring charges and the frequency of those charges, including if that price is going to change, whether it's after a certain trial period, whether it's going to change over the course of the year if you have an annual program that's a then current price, and the length of the term and the minimum purchase obligation on that day one. The FTC has now taken this position that you have to disclose what it considers all material terms of the offer. So it's actually begun to go beyond these very technical automatic billing type requirements, and it's saying things that you have to disclose things like if there's a limitation on a consumer's ability to take advantage of, let's say, a movie theater pass. There are certain blackout days and things like that. You need to actually clearly and conspicuously disclose those too. We're keeping an eye out on what the FTC is doing there. It's starting to call various practices, quote unquote, dark patterns, which it believes, which we sort of consider this new in vogue term to really encompass what the FTC thinks is deceptive. When we're talking about disclosures, it needs to be clear and conspicuous. It needs to be before you obtain the consumer's billing information. You can't provide a disclosure after the person gives you their information. In Vermont, here's one of those technical requirements. If you've got a subscription with an initial term of 1 year or more, that disclosure has to appear in bold type. So it's a very specific requirement. Getting consent, you have to obtain affirmative express informed consent before obtaining the payment card information. It needs to be affirmative. Somebody has to take an action. It must be unambiguous. Silence isn't consent. It needs to be informed so that people have to actually have seen and understand the terms of the automatic renewal before they provide that consent, because consent would not be valid if they didn't see the material terms. When we're looking at free trial offers, now we have a couple more states with specific requirements. If you have a free trial of a good or service with that free trial term of 1 month or more, wherever that auto renews, at the end of the free trial period, you have to provide a notice of that renewal that someone's going to be charged at the end of the free trial. And even if they've consented to the free trial itself, you have to obtain a separate consent to that automatic renewal, that conversion to the paid part of the program. And that consent needs to be obtained even if you already obtained consent to the free trial. So we're starting to see a lot more ARDOS requirements across the country with respect to different types of offers. And what I will say too, in addition to having all of our colleagues across the country, across the globe here, we also are seeing a lot of requirements that vary even within the United States itself, just due to the nature of these programs and due to the nature of these states. The next thing we need to do is provide an order confirmation or acknowledgement. Certain states say that needs to be in a manner that's capable of being retained. In other words, it can't simply be a pop-up. It needs to be something that people actually can retain. They can go back to their email and look at it. Even if it's not required, we always recommend doing this so that we are able to show that consumers understood the terms of the offer and that they had something they could go back and reference. In those order confirmations, this is an example of where states prescribe very specific terms that need to be disclosed. So the terms of the offer that I talked about earlier, the cancellation policy, and information about how to cancel. So those are sort of two related things. And disclosing how to cancel before consumer begins paying. And we've seen some action in this area where if a company doesn't even put, where there's no link to the cancellation mechanism, we've seen plaintiffs say that that's not fair, that's deceptive or unfair because it makes it difficult for people to cancel. To that end, there's a requirement that you provide a simple cancellation mechanism. You can't make it overly difficult for consumers to cancel. It has to be cost effective and readily accessible. Typically, that's a toll-free number, email address, or postal address. But a lot of states are now saying that if someone can enroll in an automatic renewal offer online, they need to be allowed to cancel that offer online. California, in particular, has new requirements that are going to go into effect in July, saying that if somebody is able to enroll in an automatic renewal online, they have to be able to terminate exclusively online at will and without engaging in any further steps that obstruct or delay the ability to terminate. And what that means is that you can't, what that I think is geared towards is preventing companies from doing any types of save attempts or saying, are you sure? Are you sure? Do you really want to do this? Do you really want to cancel? What if you've got what you hear and not there? The California requirement also says that termination must be either in a prominently located direct hyperlink or button, which can be within your account or profile, or it can be an immediately accessible termination email that somebody can just click on, cancel my account, click send. The law does provide a little bit of leeway in verifying the consumer's identity and account information, but really the rule of the road and the new California requirement is that they're really trying to streamline and make the cancellation process as easy and frictionless as possible. Renewal reminders need to be sent depending on the contract's initial term and the renewal term. The general rule is that if the initial term is 1 year or more and it's automatically going to renew for 1 month or more, you need to provide a reminder because people typically forget that they enrolled in something a year ago. The North Dakota law says that it also provides some additional requirements, and it actually prohibits auto renewals for greater than 12 months. So this is showing sort of this patchwork quilt of laws that say, okay, well, you can't have a 2-year program in North Carolina. The California standard provides what the notice needs to include, which is typically the same things that were in the confirmation email, but you need to clearly and conspicuously disclose the contact information for the business. The timing of these notices is becoming very interesting because we're seeing things as short as 15 days, as long as 60 days. We're seeing places where there's actually not overlap. So complying with the Vermont law might not be complying with the North Carolina law. So programmatically, it's becoming a little bit difficult as well. So that renewal reminder needs to be in a format that's capable of being retained by the consumer. Again, it can't just be like a pop-up when they go into their account or something like that. If the offer changes in any material way, which we normally think as the price, the frequency of the charges, or a material feature or benefit of the offer, consumers need to be provided a clear and conspicuous notice of that, and they need to have the ability to cancel. They need to have the ability to say, I don't want to do that. I don't want to continue on that way. And we typically advise getting consent to the charges because just as a general rule, if we're talking about contracts and things like that, there's a question of whether or not consumers have agreed to any material change in the contract to the extent these are contracts with the consumers. Some other notable state laws, Vermont requires a separate opt-in mechanism, and that what I spoke about earlier, that disclosures need to appear in bold. District of Columbia requires a notification before the end of a free trial period and that additional consent that we talked about. Colorado has some specific rules about cancellations, which are somewhat similar to the California rules, but also say that an in-person mechanism for canceling should be provided. And there are new safe harbors that are coming out. California and Delaware are saying that if you comply with the provisions in good faith, you won't be subject to penalties. But what I will say is that we have not seen that litigated. We've seen regulators sort of reject that, and they take the fact that they believe you've violated the law as evidence that you can't take that safe harbor. Enforcement of these laws are really through class action plaintiffs and the government, so Federal Trade Commission, state attorneys general, and in California, district attorneys of various cities or counties. So they have a automatic renewal task force that they use. They group together and they get really significant penalties. We've seen multi-million-dollar penalties. Monetary relief runs the gamut. The FTC has a statutory penalty for violations of ROSCA, the federal law we spoke about earlier, and they're very large, $46,000. California has civil penalties of $2,500 per violation. And we have seen we've seen cooperation both within the U.S. So these types of things brought, I think there was one against SiriusXM with all 50 states, but also with foreign regulators as needed, particularly where you have businesses that are multinational or where the owners are in one country and the business is located somewhere else where the bank accounts are and that type of thing. Litigation trends that we're seeing, we've always seen a lot about the disclosures of the charges at base. You need to tell people what they're getting, how much they're paying, when they're going to pay for it. Failing to provide a simple cancellation mechanism, that's becoming a really big area of litigation, this idea that people are being charged, and even if they knew, it doesn't matter that they knew they were going to be charged a certain amount on a certain day if they can't stop the charges. And so we've seen that, and we actually saw the FTC get a sort of substantial win on this issue in the case against MyLife, where it said that the company did not provide a simple cancellation mechanism where people could only do it by calling in, and then they were unable to reach somebody. So sometimes they're put on hold for 30 minutes, they got disconnected, the customer service representatives, according to the FTC, would engage in these aggressive attempts or assertive attempts to say, do you really want to cancel? Are you sure? What about this? What about that? And so the FTC said that was not sufficiently simple under the federal law, and the court agreed. The court said that violated ROSCA. So we've got a little bit of guidance. And I'll say right now, I think Ellen and I both dealt with this a lot, is that there isn't a ton of guidance on the federal law because a lot of these things haven't been litigated. This law went into effect, I think about, I don't know, a little bit over a decade ago. So it hasn't been litigated. We don't have as much guidance as we want. We really look to what the FTC is challenging and what private plaintiffs are challenging to see what the expectations are, and determining where the goalpost in particular has been difficult in the U.S. The other area of risk is the card brands, so payment processing. If a company can't process payments, that sometimes is business ending, or even more business ending than an FTC action. So Visa has certain rules applying to free trials and introductory offers, requiring that people send terms of subscription via email, and an email notification before initiating a recurring transaction, and an online cancellation mechanism. MasterCard has new rules this year, including certain disclosures before enrolling people and obtaining consent, explicitly providing where the disclosures need to appear, and guidance about what is and isn't sufficient. You'll need to send an enrollment confirmation immediately after enrollment, and after each billing, sending a receipt. And if the period between billings is 6 months or more, sending a subscription reminder 3 to 7 days before the card is automatically charged. So again, we're seeing a lot of these more technical requirements with the end goal of making it easier for consumers to understand what they're being charged, when it is, and letting them cancel that. And what I'll also say, I mean, I know we've gone really quickly through a lot of these new laws, and these laws are being passed consistently. They're being amended consistently every year, at least a handful of new laws or changed laws, and they're not consistent. The only thing that's consistent is that they're inconsistent. And even in the card brand, so MasterCard said that these were going to be effective in March of 2022. It actually announced that this is going to be enforced beginning later in the year. So it understands too that operationally this is very difficult for companies.
Okay.
So with that,
yeah, go ahead.
Oh no, go ahead. I'm sorry.
I was just going to turn it over. So no, we did, and so yes, indeed, lots going on there. And Shahin and I liken this almost to privacy laws here in the United States. I've always said no, this stuff isn't as complicated as our privacy laws, but with the different patchwork of state things happening, we're wondering if it's going to get to that horrible, inconsistent place. But anyway, let's turn it over and to Jacqueline and talk about Canada. So take it away.
Thank you. My name is Jacqueline. I'm a partner in Miller Thompson's Toronto office. So in Canada, we have consumer protection laws, and these are generally at the provincial level. So most of our provinces have these laws, except for New Brunswick and Prince Edward Island. Our 3 territories do not really have legislation on this particular topic. So my focus today is going to be on the online subscription agreement. And this in our legislation is sometimes referred to as an internet agreement, a distance contract, a remote contract, a future performance agreement. There's all sorts of different lingo around it. And it doesn't necessarily focus specifically on the subscription aspect of it, but there are elements of certain prohibitions and compliance requirements that would apply specifically to those types of contracts. And this could be for subscriptions related to goods or related to services. And in terms of our key requirements, they're very similar to the ones that we're focused on in the US, but the rules themselves differ slightly. So there are certain disclosures that need to be provided to the consumer before they enter into this type of contract. So we're looking at things like itemized purchase price, including what specific costs outside of just the price of the product, so taxes, shipping, even if there's like a brokerage fee or a customs duty, that needs to be disclosed. Any details regarding the periodic payments, so again, very similar to the US, the amount, timing, frequency, an actual detailed description of the goods or services, and then also information about the policies of the company, so related to returns and exchanges, to warranties, to what the actual delivery process is. We would typically see that information in like terms and conditions rather than the checkout flow. But usually there would be like a link to the terms and conditions before actually hitting the submit or subscribe button. As we're going to talk about just shortly when we talk about material changes, there should also be clauses that indicate what other clauses in the terms and conditions could change in future, and that kind of helps the unilateral amendment process. And then any other material facts that might impact the consumer's decision to actually make that purchase. And again, similar to the US, the disclosure has to be clear and conspicuous. It needs to be made before the consumer makes that purchase and subscribes. There needs to be an express opportunity to accept or decline the contract, and the consumer has to be able to retain and print the information. And so that will bring me to my next slide. So usually we find these disclosures in multiple places. So as I mentioned, it could be in the terms and conditions, it could be in the checkout flow, and some of the information might also be in the order confirmation email. So usually what Canadian businesses would do, or businesses that are selling to Canadian consumers, is make sure that your order confirmation email includes all of the prescribed disclosures that need to be in the consumer contract so that they can easily print it. So you'd have a link to the terms and conditions. The information that was in the checkout flow, all of those disclosures would be restated in the order confirmation. And then the consumer and the supplier's contact information would need to be in there as well. And this needs to be provided within 15 days of actually entering into the subscription agreement. And again, it would be that combination of documents so that the consumer can easily print and retain it. So in terms of cancellations, you can't necessarily cancel all internet agreements without a penalty type of clause applying. So there are certain types of agreements, though, where they require cooling off periods. That would be, for example, a gym or a fitness membership, which has its own requirements outside of just the typical internet agreement or subscription situation, because you might be entering into those agreements in person. Those usually have like a 10-day period where the person can cancel, and then the organization has to return their money within 15 days. We also have unfair business practices. So a person can cancel within 1 year of entering into the contract and get a full refund on anything purchased if it turns out that the goods or services were false or misleading or described in a deceptive manner. And then in particular related to subscription agreements, if the deliveries are not made on time, so usually within 30 days of whatever that indicated delivery date is, then the consumer can cancel that subscription agreement for a full refund. Otherwise, it just depends on the timing and what the terms and conditions of the company say in terms of how its cancellation policy would work. In terms of our free trial offers in Canada, so where the contract automatically renews at the end of the free trial, there are certain disclosures that the seller must make before the consumer enters into the free trial. So again, very similar to the US, there has to be a disclosure of what the price will be after the trial period ends, and this needs to be done very prominently in that first advertisement. There also has to be information about how long that free trial will last, and an indication or some type of statement that the consumer can cancel the contract at any time. And the price that's advertised as being the actual subscription price can't be changed until after that first full month of being charged the regular price. But otherwise, as long as those requirements are met, then there isn't generally a requirement to get an additional consent or an additional notice after the free trial is over. In terms of our renewal requirements, so it depends on how the contract is actually described. So if you have a contract and it's of a fixed term, generally you do require advance notice of the renewal, typically 30 to 90 days. However, if your contract didn't originally contemplate that it would be an automatic renewal contract and you want to have that automatic renewal, then you actually have to have express consent of the consumer and disclosure of what the key terms will be for that renewal period. How we're seeing our clients kind of get around the renewal reminder issue, particularly because sometimes you get the reminder and then the consumer doesn't necessarily want to renew, so they're trying to avoid having to send those reminders, is to recharacterize the contract as one of an indefinite term. So it's still automatically renewing, but it's of an indefinite term. So it's more the payment portion of it that's automatically being charged again. So whether the contract is considered of a fixed term or indefinite term depends on how this information was initially communicated to the subscriber and what has been reinforced by the company's conduct. So if the company had a practice of usually sending renewal reminders and the initial terms of the contract described it as an annual subscription rather than an ongoing subscription, then that would push it more towards being of a fixed duration, in which case then you would need to make sure you provide that renewal reminder in advance. So what we're seeing is changes to the terms and conditions to remove language like terms and renewal, and instead talking about it being of an ongoing duration, and rather talking about what the billing or payment cycle is and the delivery cycle. And that's kind of the way of trying to avoid having to send those renewal reminders. And then as it relates to making a material change to the contract, so these rules tend to vary by province. In terms of what's material, again, we're talking about subscription price, the duration, what the actual goods and services are, the delivery terms and the timing for billing, and then anything else that could be considered material based on that particular subscription contract. So if a company was to take a strictest standard approach across all of Canada, then typically we would say get express consent from the consumer and actually have them take a positive action before trying to make a material change. However, if you wanted to take more of a province by province approach, then generally the material changes fall into 3 different categories. So there are express consent provinces where again, the company needs to have express consent if you want to make a material change. There are certain exceptions. So for example, Ontario, if notice, you could have it so that notice is only required with 30 to 90 days of advance notice provided, as long as the clauses that you're talking about in terms of making a change. So let's say we're focusing on price. As long as your terms and conditions say that your price is subject to change, then you can do it on a notice basis and don't need to get express consent. But there still needs to be an option for the consumer to terminate, and they need to understand what's going to happen if they don't do anything. And then for Quebec, they have a very similar requirement, but it only applies to indefinite term service contracts. So again, we're going back to that concept of it not being an automatic renewal of a fixed term contract, and it needs to relate to services. For BC, you can have price changes, but again, it needs to be done where you're letting the consumer know in advance in the terms and conditions when they're signing up, and also in the checkout flow. It needs to be very prominently made noticeable to them that this change is going to happen. Other provinces, which we'd call contractual inclusion provinces, these are ones where notice is fine. There isn't anything expressly prohibiting a material change, but we do have the prohibitions regarding unfair practices and unsolicited goods and your negative option clauses. So the terms and conditions initially should disclose that the company might make a change to a material term, and then on that basis, providing notice in advance of the change would be fine, and you wouldn't need express consent. And then finally, we have provinces where they either don't have consumer protection legislation for internet agreements, or they're silent on how they treat unilateral material changes. But in Canada, our common law would still apply in terms of contract formation. So the courts would likely be hesitant to allow a unilateral change if it's going to impact the contract in a fundamental way, just because you're dealing with parties who have unequal bargaining power. So in this case, our suggestion is usually to not make that unilateral change unless it's very clearly communicated to the consumer that that is going to happen. And then finally, I will just briefly go over Quebec. So I would say the key things to take away with Quebec, because there are slightly different requirements here, is that even if you're making a non-material unilateral change to the contract, you still need to provide advance notice and disclosure of what the change is. There is a prohibition for having an online service agreement with a term of more than 60 days in terms of having an automatically renew for a fixed time. So again, we usually in Quebec either don't have that automatic renewal, or you try and make the contract of an indefinite term. They have the right to be served in French, so terms and conditions, website, everything should be translated into French. And then they have additional requirements as it relates to disclosure for monthly charges and total all-in pricing. I would say that Quebec generally is much more litigious than other provinces in Canada. They tend to have more class actions, especially focusing on the consumer protection legislation there. So if you are selling to consumers, or the company selling to consumers in Quebec, that's one area to be much more mindful of, making sure that you're in compliance. And with that, I will turn it over to Brinsley.
Thank you very much. Oh, this is the problem of having two screens. It's on the wrong screen now. Okay, I will muddle through. Forgive me for looking down instead of looking up. So I'm approach this in a way of trying not to just repeat what colleagues have said, because a lot of the laws may be different, but a lot of the underlying principles are very similar. Not, I think, because the world looks to the UK for leadership in these matters, but certainly the same kind of consumer protection issues, I think, arise all around the world, wherever you are. So I thought it would be useful, though, just to set out for you on this first slide the sort of three statutes which are where you will find the law if you're looking for them for reference, which are the Consumer Protection Regulations 2008, which is the way that the UK implemented the Unfair Commercial Practices Directive when we were still a member of the European Union, but this still remains the law and is likely to. It's a very good piece of law, principles-based legislation. Then more specifically, we've got the Consumer Rights Act 2015 and the rather pithily named Consumer Contracts Information Cancellation and Additional Charges Regulations 2013. And I've put those acronyms in there because it comes up on another slide. Now, as well as all the law, we've also got the self-regulatory regime. And those of you who've heard me speak before on these events will know that in the UK, we do place a lot of reliance on advertising regulation on the Advertising Standards Authority, our self-regulatory authority. It's not perfect, but it is quick and it's cheap. And it is, by and large, its decisions are very well implemented and regarded and followed, particularly by any kind of major or legitimate advertiser. The key principles of these, so auto-renewal terms should be made clear at the outset in a transparent and prominent way during the sign-up process. Traders need to remind consumers that a renewal is coming up well in advance of the start of the renewal period. Traders should also provide clear instructions about how the consumer can terminate the contract before the renewal period begins and or any payment is charged in relation to the the renewal period. And then finally, consumers should be given a right to cancel the contract once it's been renewed without having to pay a cancellation fee on reasonable notice. Does this always happen? No, it does not. As I pointed out to the manager of the new gym that my wife signed me up to, and I was thinking, there's no way I'm going to renew for a second year. And then they told me, well, tough. You can cancel after 2 weeks. And I thought, not sure about that. But I don't know whether they've heard what Jacqueline was saying about an indefinite contract. So maybe that's the way they're going. I thought that was really interesting. And I'm not aware of any clients trying to pursue that route. It would be interesting to see whether that would work under UK law. That did sound very, very interesting. There's been a very recent development just last week. The CMA, which is the Competition and Markets Authority, that's the UK equivalent of the FTC. So it's the statutory regulator. They kind of mean business, these people. One stat they put out was that the average UK household spends £60 a year on unwanted subscriptions. And when you think about it, well, that's only £5 a month, I think. It's not very much anyway. Maybe it's more than £5 a month. But it's not very much. And I was thinking about, in my own family, I mean, I keep discovering that my wife and I have both got Netflix accounts. We've both got family Spotify accounts. It's very easy. And then you find out the kids have got them as well. It's very easy to kind of realize that you've got loads of these things that you signed up for and they're still running. So under these new rules, as you can see, the CMA said that businesses have got to provide clearer information before they enter into a subscription contract. They've got to issue reminders that a free trial or low cost introductory offer is going to end. and a reminder before the auto renewal comes into place, and ensure that consumers can exit the contract in a straightforward, cost-effective and timely way. So actually, this is just a restatement of the existing law, but it's kind of reminding people that these are the steps that have to be taken. In some ways of more significance was this announcement that in order to enforce the laws, the CMA is no longer going to actually have to take people to court. They're going to be able to impose what the press release called a financial penalty. They seem to have avoided using the word fine, but you know, what's the difference between a fine and a financial penalty? It seems like the same thing to me. And they're potentially quite hefty. So breaking consumer laws, you can be fined up to 10% of global annual turnover. Breaching undertakings given to the CMA, fines of up to 5% of annual global turnover. And non-compliance with an information notice or concealing evidence or providing false information. So the CMA is doing an investigation and you give them false or incomplete information, you can be fined 1%. Excuse me. So these are quite hefty, and it's the CMA kind of taking concepts from competition law enforcement and applying them now to consumer protection law enforcement. On the self-regulatory side, these are the two main rules that the ASA relies on from what's called the CAP Code, Committee of Advertising Practice Code. So a sort of high-level obligation to conduct promotions fairly in 8.2, and then an obligation in 8.17 to provide all the significant applicable conditions for a promotion so that people aren't misled. And as you'd expect, that kind of reinforces the underlying law and reflects the underlying law. The ASA has issued some guidance, which again, it's these same things about, you know, whether a subscription starts automatically, the extent of the financial commitment, the other significant conditions. It's not different, it's consistent with the underlying legal principles. And then finally, to finish with, I just wanted to mention an example. This is a reasonably recent example from the 1st of April 2 years ago, April Fool's Day, where Warner's Group, who publish I think the full title of this glorious publication is British Railway Modelers, available in all good stationery stores. And they were giving away a £60 goodie bag and a ticket to an event and 5 issues of the magazine, all for just £5. Click here to claim the ridiculous offer. Now, the problem was the ad didn't say that this then required you to sign up for a subscription to the magazine. That only became clear when you had clicked and gone to the website. But by that point, it was sort of too late. A transactional step had been taken to go from the online ad to the website, and therefore the online ad was incomplete and didn't have all of the relevant information. So the ad itself was misleading. So that's a whistle-stop tour of the situation in the UK, and I think now it's over to Virginie. You're on mute, Virginie.
Thank you, Brinsley. Well, for Luxembourg, I would say that the Luxembourg legal framework, of course, is quite the same as in the US or in the UK, as you presented, Brinsley. Well, the automatic renewal programs will fall within the Luxembourg Consumer Code, and as well as the Luxembourg law of 2016 related to sale and market sale and misleading and comparative advertising. So without really going into details, well, automatic renewal programs comply with general Luxembourg regulation on commercial practices and advertising. And of course, it must not be misleading or confusing for consumer. If we go to the next slide, so the fine are not as heavy as it is in the UK, I would say. Well, failure to comply with general Luxembourg regulation on advertising and commercial practices may result in the prohibition of the ad or the program, and it may also lead to the posting or publication of the judgment if there's litigation, which is obviously negative publicity for the professionals. Professional may be sentenced to pay damages, which in Luxembourg is limited to direct and foreseeable prejudice. There's no punitive damages in Luxembourg, and the professional may be also sentenced to criminal fines, which are quite not really big. So which go from 251 euro to 120,000 euro. So this is not a lot. So if we go now to the tips to consider for the Luxembourg market and in comparison with the US, we do not have specific requirements for renewal program to provide terms and conditions, but it remains standard practice. When we talk about terms and conditions, we have a provision in the Civil Code which say that general terms and conditions of a contract which have been pre-established by one of the parties are binding on the other party only if the latter has been in a position to have known them at the time of the signature of the contract, and it should, according to the circumstances, be considered as having accepted them, which leads to some specific condition. Well, the professional needs to give a certain number of information about the goods or the service, the list of the information to be provided before the conclusion of the contract is the idea of the professional and its details, the characteristic of the goods and services, the price and all taxes, the payment method, the way the contract will be enforced, and the condition, as well as if there is withdrawal rights or not. So regarding the question of confirmation and recording of information, Luxembourg law provides that the consumer shall receive at the latest at the time of the delivery of the product or performance of the service on a sustainable support at his disposal and accessible to him the confirmation of the information, which I just mentioned, as well as where applicable the condition for exercising the right of withdrawal. In terms of renewal programs, I would say that the consumer code provides that the consumer shall be informed of the term of the contract, if any, or in case of indefinite or automatically renewable contract, the condition for the termination of the contract. In the same way, if there's a material change in the contract, in the program, there are no specific provision, but for sure, and according to the good faith principle, professional must inform in advance the consumer about the change. And if this change are really material change, that means that it concerns the essential condition of the contract, then the professional shall give the consumer the right to terminate the contract and not to accept the new condition. So as mentioned for the US or in the UK, the terms and conditions must be clear and visible, as well as the commercial background of the program. The term and condition must be easily understandable by consumer. Regarding Luxembourg, specific Luxembourg aspect, there's no obligation to translate terms and conditions, but it's still recommended to provide members or consumer with the terms and conditions into at least one of the Luxembourg official languages, which is Luxembourgish, German, or French. So this is really the tips to consider. And if we can, to finish with the small presentation for Luxembourg, in international context regarding renewal programs running worldwide, Well, the governing law in B2C relationship is in principle the law of the country where the consumer has its residence, provided that the professional direct its activity to that country. But when there's no promotion organized in Luxembourg, but Luxembourg resident can nevertheless enter the program, Luxembourg resident will still need to have the benefit of the Luxembourg mandatory provision, which include some provision of the consumer code, as well as all the GDPR regulation will also apply. I think we will finish now with India.
Hi everyone, I'm Kanu Priya. Thank you for joining us. I'm a partner with the firm Cannon Fishme based in Delhi. I'm going to briefly cover Indian regulations regarding automatic renewal programs and then compare the position in India with that of US. The Reserve Bank of India, which is India's central bank and primary regulatory body, has recently notified that auto debit transactions performed using all types of cards, be it debit card, credit card, or prepaid payment instruments, including wallets, can only be processed if a pre-debit notification is sent to the consumers at least 24 hours before the payment is due. So for auto transactions above 5,000 rupees, which is equivalent to US $65, the consumers would need to authenticate with a one-time password. The Reserve Bank of India has also notified the steps for processing of e-mandate on cards for recurring transactions. A cardholder who wants to opt for e-mandate facility must undertake a one-time registration process with additional factor authentication validation by the issuer. So an e-mandate on card for recurring transactions can only be registered after successful validation, in addition to the normal process which may be required by the issuer. And for registration, all requisite information would be required, including the validity period of the e-mandate. During registration, there's an option which is given to the cardholders to provide the e-mandate for either a pre-specified fixed value of recurring transaction or for the variable value. In case of variable value, the maximum value of recurring transactions subject to the overall cap has to be specified. This validation has to be performed while processing the first transaction in the recurring transaction series, and the subsequent transactions may be performed without the validation. The issuer also has to send a pre-transaction notification to the cardholder at least 24 hours prior to the actual charge or debit to the card. And on receipt of this pre-transaction notification, the cardholder should also have the facility to opt out of that particular transaction or the particular e-mandate. After the transaction, the issuer also has to send post-transaction alert or notification to the cardholder. And the cap for the e-mandate based recurring transactions is 5,000 rupees, as we discussed in the previous slide. And the issuer has to provide the cardholder an online facility or mechanism to withdraw any e-mandate at any point of time, following which no further recurring transactions will be allowed for the withdrawn e-mandate. Coming on to the requirements under Indian law, the main requirements under Indian law are a complete disclosure of all material information concerning the transaction, including amount of recurring charges, length of the subscription term, automatic renewal upon the end of free trial period, details about cancellation policy, deadline of cancellation, and any other relevant information. Also, there should not be any hidden cost. If there's a hidden cost, it amounts to unfair trade practice under Consumer Protection Act 2019. And obviously, it should not be misleading or deceptive. Again, that counts as unfair trade practice under the Consumer Protection Act of 2019. Another thing which is mandatory is to obtain express informed consent of consumers. The consent must be affirmative and it should not be ambiguous or implied. Also, the consumer must give informed consent. That is, he must have been informed of the relevant terms of the transaction before giving the consent. There should also be a simple online mechanism of cancellation of the automatic renewal program at any point of time. And another requirement is that a post-transaction confirmation has to be sent to the consumer, which should include at the very least the acknowledgement of payment and information on how to cancel. The merchants or service providers must also send advance notice of any material modification. The most important material modification is obviously changes in price. So an advance notice must be sent for the same. And this notice should also contain information on how to cancel. That is, if it's not acceptable to the consumer, if the increase in price is not acceptable to the consumer, they can cancel the automatic renewal offer. And so the information regarding how to cancel the automatic renewal offer should be given in this advance notice. Now let's compare the Indian laws and regulations concerning automatic renewal programs with relevant US laws. As discussed in the previous slides, as far as the disclosure is concerned, India has similar requirements to US. In India also, it is mandatory to disclose all material information, including amount of wrecking charges or length of subscription term. It has also, it has to be disclosed that the subscription will continue until it is cancelled. And another thing which has to be disclosed is that after the end of free trial period, there will be automatic renewal, and the consumer will be charged automatically unless he cancels the subscription before the end of trial period. The details about cancellation policy and deadline of cancellation also has to be disclosed. So basically, all the relevant material information should be disclosed, and there should not be any hidden cost. Hidden cost amounts to unfair trade practice. Now, as far as consent is concerned, again, India has similar requirements as that of US to obtain affirmative express informed consent. That is, the consent should not be silent, it should be express, and it should be an informed consent, as in the consumer should be well aware of what he is consenting to. Now, coming on to the free trials. So, as far as free trials are concerned, Indian laws vary slightly from US laws. Here in India, the consumers must be aware, must be informed at the time of registration or initiation of free trial that they would be automatically charged at the end of trial period, unless they cancel the subscription before the end of trial. So, unlike US, it is not mandatory in India to send automatic renewal reminders or to notify the consumers that their free trial period is about to end and that they will be charged at the end of trial period. It is sufficient if at the time of start of the trial period they are informed that at the time of end of trial period they will be charged. That's sufficient. There's no need to notify again that their trial period is about to end. Also, it's not mandatory to send renewal reminders before the monthly automatic renewal. As far as cancellation mechanism is concerned, the requirements in India are similar to US. Here also there is requirement for simple online mechanism to cancel automatic renewal offer at any point of time. Also, there is requirement for post-transaction confirmation, which has to be sent to the consumer. So this confirmation, like I said earlier, at the very least should include the acknowledgement of payment and information on how to cancel. Another important requirement, which is similar to US, is advance notice of any material modification. So like US, here also we have to give an advance notice regarding material changes, particularly related to changes in price. And the notice should include information on how to cancel. Also, it would be preferable that the affirmative consent is obtained for the material changes from the consumers. So that would be, that would be preferable. Well, this concludes my presentation. Thank you again.
Okay. I will just wrap it up because I know we're hitting the top of the hour. I believe the slides will be available. If somebody clicks through to the next slide, I think there's a few resources there. And I know that we all want to thank the Alliance for putting this together. Any of you who are attendees, if you are in other jurisdictions, we would love to hear about what's going on in your parts of the world. And it would be really great to, this is a great slide deck, I think, to reference in these places, and something that perhaps we can build out for our broader group in other jurisdictions too. But very informative. I know I learned a lot, and I just wanted to thank everybody for dialing in or zooming in or videoing. So, okay. Well, any other last words? I know we're at the top of the hour and I want to be mindful of time. So none for me, and I'll say thank you, but thanks to everybody. Okay.
Thank you.
Yeah.
Thanks, everyone.
Bye.